Good morning. I'm Lauren LaFlamme with Bankers Insurance, and welcome to our webinar on Human Resources Legal Updates. Presenting today is Jamie Hasty from SESCO Management Consultants. This webinar is being recorded, and I will share the recording at the conclusion of the webinar. Please place your questions in the chat, and we will have a Q&A at the end of the session. With that, I'll turn it over to Jamie, the Vice President of SESCO Management Consultants. Thank you.
Thanks, Lauren. Good morning, everybody. It's a pleasure to be back with you. My name is Jamie Hasty. I'm Vice President with SESCO Management Consultants. Familiar with many of you on the call, or Zoom today, rather. But as you may be aware, SESCO has been partnered with Bankers Insurance since 2014 to provide some basic access and HR consulting services to bankers' clients. So if you are not sure if you have access to SESCO, feel free to reach out to your representative through Bankers and we can double check that. So with that being said, let's talk a little bit about some of the HR legal updates that are going on. It's important to remember that these are solely looking at federal updates. There's obviously a lot that goes on at the state level that, of course, we need to comply with as well. But for purposes of today's webinar, it's going to be focusing on the Pregnancy Fairness and Workers Act, the PUMP Act, which amends the Fair Labor Standards Act slightly. It's not a huge change there, but it's something that I do want to cover. Obviously, we're going to spend a good chunk of time on the wage and hour piece with the proposed change and salary exempt threshold. And then we'll end our time today with some changes to the I-9. Now, to Lauren's point, please put your questions in the chat feature. When I am presenting, I cannot see those questions. So what I'm going to ask is that Lauren monitor those questions, and as they come in, before we move on to future sections, that she kind of will read those aloud to me and allow me to answer those questions for you. So let's jump in. So there's been some updates to pregnant worker job protection laws. And one of those changes is what we call the Pregnancy Worker Fairness Act. So this is going to require covered employers. So any private or public sector employee that has 15 or more employees, okay? Now, if you were under 15 employees, please remember that likely you are also covered by a separate state regulation that will have job protection provisions as well as employer requirements for pregnancy. So here in Virginia, we have the Virginia Pregnancy Act. If you're in North Carolina, there is, a version of that as well. So remember that even if you were under the federal thresholds, likely there is going to be a state law that covers you in some form or fashion as well. So the Pregnant Workers Fairness Act is going to apply to employers with 15 or more. And that requires us to give reasonable accommodations to individuals that are pregnant, postpartum, lactating, unless those accommodations, reasonable accommodations, would constitute an undue hardship. Now, you'll hear me talk about undue hardship through both this act as well as some of the other pieces. Please remember that trying to determine undue hardship and justify undue hardship is a very, very difficult threshold to meet. So when Department of Labor looks at undue hardship, whether that's through this act or the Americans with Disabilities Act, they are really looking at it with a very fine-tooth comb. And basically Department of Labor, federal, has taken the stance that anything can reasonably be accommodated unless it's really going to require hundreds of thousands of dollars. They used to talk about undue hardship as it relates to disruption of business operations, and they have recently kind of pulled back that interpretation. In fact, I've seen some opinion letters as of recent where DOL said, it's not enough. Even if it's inconvenient, even if it's disrupting your business operations, it's not going to rise to the level of undue hardship. So just know, yes, there is a provision in there for undue hardship related to reasonable accommodations, whether that be for pregnancy or any other disability. It is just a very, very difficult threshold to establish. So prior to the Pregnant Workers Fairness Act coming into play, we were only required to provide accommodations for pregnant workers when accommodations were granted to other people who were not pregnant, okay? So with the PWFA, it really does in many ways interplay with the Americans with Disabilities Act, as well as Pregnancy Discrimination Act. So on a federal level, we have Americans with Disabilities. We have the Pregnancy Discrimination Act already that's been around forever, as well as your state laws. But this in particular is going to look at postpartum accommodations and current lactating employees. It doesn't necessarily have to be solely a pregnancy-related disability to receive the accommodation. All right. So more specifically, the EEOC, the Equal Employment Opportunity Commission, they are the agency within the Federal Department of Labor that looks at charges of discrimination. Okay. Whether that be an applicant, a current employee, a separated employee. So the EEOC has taken this regulation that the Department of Labor has enacted, Congress has enacted, and basically has looked at how do we implement this. And they've issued some proposed guidelines. Those are currently in a 60-day comment period. Now, if you're familiar with regulations, what happens is when there are new regulations implemented through the Department of Labor, or there are proposed changes to any current regulation, they all have to go through an open comment period. So, some of these things that the EEOC is proposing in terms of enacting and enforcement may or may not be modified between now and the time that the regulation is fleshed out in their eyes. However, EEOC is basically also recommending or wanting to include conditions related to pregnancy. It's broadly interpreted. So childbirth, breastfeeding, miscarriages, abortions, as well as any sort of limitation due to menstruation, infertility, and fertility treatments, as well as endometriosis. So when we talk about the Pregnancy Worker Fairness Act, it may not just be childbirth, postpartum, breastfeeding. It could very much so include other pregnancy-related pieces, whether that be fertility, infertility, endo, and miscarriages and abortions, okay? So with this act, we have to reasonably accommodate these folks, right? That could be a number of things. It could be, I need to sit down and have a drink of water more frequently because I'm dehydrated related to this procedure or postpartum. I may need to receive closer parking spots because of walking and, my limitations there. I might need more flexible hours, different safety apparel, different uniforms, additional break time necessarily does not have to be paid, but I may require and receive additional break time. I obviously am going to be able to take leave or time off to recover from childbirth. Now, with that reasonable accommodation, that's no different than ADA as well as pregnancy discrimination, or even on a state level here in Virginia with the Virginia Pregnancy Act. You have to give them time off to recover from childbirth. That could be anywhere from 6 up to 12 weeks. And remember that short-term disability benefits may or may not play into that, as well as the length of time, but typically that time off is determined by the medical provider based on the type of delivery that this individual had. So we have to reasonably accommodate that. They may also be excused from any sort of strenuous activity or that an activity within the workplace that could expose them to unsafe situations for their pregnancy. So these are just some examples of the reasonable accommodations that can be provided under the new regulation. Okay. So when we have a situation where an employee requires an accommodation, childbirth, pregnancy, post-birth, or any of these other medical conditions that they may be dealing with, we have to engage in what we call an interactive process. Again, this is no different than what we would be doing under the Americans with Disabilities Act. It's a good faith conversation. Now, here's the other piece. If we as the employer have knowledge of the condition or notice that their performance is slipping or that they're struggling to complete certain tasks, this is not a situation where the employee has to come and ask for an accommodation, okay? Similar concept when we're dealing with family medical leave. Common misconception is the employee has to request the FMLA. That is not true. If we have knowledge, it's enough to rise to the threshold where the employer may need to initiate the good faith conversation of the interactive process, okay? You can do it via telephone, email, or any other way that's conducive to the situation. But we have to respond. They can absolutely come and request an accommodation, but it's not necessarily one of those situations where that is required. Now, the other piece with the reasonable accommodation process, again, no different than ADA, is that you cannot force the employee to take whatever you're offering, okay? We cannot necessarily force them to take an unpaid or paid leave as well. Now, again, a lot of these situations are very unique to what is going on with the individual. So can we offer an unpaid or a paid leave of absence? Absolutely. That does not necessarily mean the employee will take it. It doesn't necessarily mean that we can't come to an agreement on that, okay? But it's a back and forth. It is a negotiation based on the medical certification from the provider. Here's what we think we might be able to do. And we kind of talk back and forth about that. What's reasonable? What's not reasonable? I get a lot of questions, whether it's disability or pregnancy, where clients are calling and they're saying, hey, the doctor themselves, said, oh, well, you need to accommodate them with X, Y, and Z. Do I need to follow that? Not necessarily. It doesn't mean that just because the medical provider said, oh, they need 4 hours or they have to take breaks every 15 or 30 minutes, that we can accommodate that. Certainly we take that into consideration, but each specific situation is unique to itself. So the other piece with the Pregnancy Worker Fairness Act, it does require us to update our EEO posters, so make sure you're doing that. And this law took effect June 27th of this year, okay? Again, it's not completely different from what we've already been doing. However, it is a new separate regulation that we need to comply with. Lauren, are there any questions thus far on that?
No.
Great, thanks. All right, so let's talk briefly about the PUMP Act. Now, many of you all may be familiar already with the breaks for nursing mothers. That was part of the Healthcare Reform Act that came in, or the Affordable Care Act, excuse me, that came into play back in 2013. That amended the Fair Labor Standards Act that requires employers covered underneath the FLSA to provide, reasonable breaks for nursing mothers in a, private area up to the first year after the baby was born, right? So that's already been in play. The PUMP Act technically went into effect in December of 22 when President Biden signed it into law. However, this PUMP Act is kind of an amendment to the breaks for nursing mothers, right? So basically what this act does is it updates that to require employers of all sizes, regardless of whether you're covered underneath the Fair Labor Standards Act or not, because some employers are not. It requires all employers to provide a reasonable amount of break time in a clean, private space. Again, it cannot be a bathroom, for lactating workers to express milk up to 1 year following the birth of the child. Now, that's not really different, with the exception of everybody is now covered. So what this act also does is it allows employees to file a civil lawsuit against an employer who fails to follow the Pump Act provisions, which are effective, technically the enforcement and the effective date is April 28th of 23. Okay, so things that are important underneath this. When we have lactating individuals and they are taking time off to pump, they must be 100% completely removed from duty. Okay, 100%. It's no different than if we were talking about an employee who was taking a meal period, taking their lunch, their dinner, or a different type of break. Department of Labor says if an employee performs any work during a break, it must be paid. Okay, so with this, if the nursing employee is not completely removed from duty, or the time, then the time spent must be counted as hours worked for purposes of minimum wage and overtime requirements. Okay, so again, they need to clock out. This is an area of opportunity where you need to work with your employee to make sure that they are completely removed from duty and that time is not counting as time worked. If you already provide a paid break time and the employee chooses to pump during that time, they need to be compensated the exact same way as any other employees are compensated during that break time. Okay, so case in point, if you pay for lunch or you pay for dinner up to 30 minutes, and that employee is, using that paid 30 minutes to pump, you can't say, oh, well, technically the pump time should be a separate break and we're not going to pay you for that. Okay. Again, similar to the Pregnancy Fairness Workers Act, this also does require us to update our FLSA poster because, again, it's covered underneath this. Let's talk a little bit about the private space. We've had many a question over the years under the Breaks for Nursing Mothers about what is defined as a private space, or I'm a small employer and I don't have a private space. So the space has to be free from intrusion from coworkers and the public. We must absolutely ensure that the employee has privacy. So there could be a display sign while on the door or while somebody's in the room. There could be a door with a lock, and that's preferable where they, don't have to worry about people coming in while they're pumping. But they have to be out of view as well. So, if there is a window on the door, there needs to be a window covering to provide that privacy. Again, this cannot be a restroom. Also, if we have remote employees that are working from home, certainly, they also have protections underneath this act where they are free from view by any sort of computer camera, security camera, web conferencing platform, those sorts of things. And then also, while all employers are covered underneath the Pump Act, technically, employers with under 50 employees might be excused from complying with the law in an incredibly rare situation, providing that the required break time and space poses a significant difficulty or expense, aka we're talking about an undue hardship here again. Again, significant undue hardship. That's very difficult to prove. And before we, walk down that path, you want to make sure that you are consulting with your employment attorneys at SESCO or your consultant at SESCO to make sure we're not opening ourselves up to civil litigation. Okay. There are penalties involved for non-compliance. There are procedures that the regulation outlines for compliance. So if we are failing to provide or abide by that break time requirement, or we're not giving them a private place to pump, the employees must give us as the employer a notice of the failure, and we have 10 days to abate the failure. Okay, we have 10 days to correct it. Okay, if we don't, then they have the ability to file both civil litigation and or a complaint with the Department of Labor. Okay, so it's important that all of your managers are trained on how to handle these requests. Okay, again, it's not completely different from the breaks for nursing mothers and what we've currently been doing, but it's important that your managers understand the employee rights and then our responsibilities as leaders within the organization to comply with this. If we refuse to provide an accommodation or state that we absolutely are not going to do so, then the employee can immediately file that lawsuit. Okay. Again, if they file a complaint with the Department of Labor Wage and Hour Division, there may be compensatory damages, liquidated damages, which liquidated damages is basically doubling your penalty. Okay, so if they fine you $25,000 and impute liquidated damages, that fine automatically becomes $50,000. Okay. It could also be economic losses. It could be reinstatement, promotion. There's a variety of things. So the Wage and Hour Division, because the Pump Act amended the Fair Labor Standards Act again, that's why the Wage and Hour Division is overseeing the enforcement of this act. Remember that the Wage and Hour Division also enforces minimum wage, overtime, salaried, exemptions. So if they come in for one thing, chances are they're going to say, oh, by the way, let's go ahead and take a look at your payroll for the last 2 years. Okay, they have the ability to do that. So we don't want to run the risk of opening ourselves up to further audits for failing to comply. Any questions particularly on the Pump Act or the breaks?
We have one question that says, in regards to the PWFA, are hysterectomies included?
That's a great question. Right now, they have not listed that, but it could possibly because it relates to reproductive rights. So I think that question or that clarification, hopefully, will come out of the Department of Labor with regard to defining all of the conditions that it may apply to.
Okay, thank you. And then another question was, we are not a covered FMLA business. However, am I correct that the PWFA would apply if we have 15 plus employees at any point during the year? Our employment numbers fluctuate.
Yes, even though you may be not covered under Family Medical Leave Act, which applies to employers with 50 or more within within 20 calendar work weeks, and the calendar work weeks need not be consecutive. So if you're one of those employers that has a lot of seasonal staff where your numbers significantly fluctuate, if you're hitting 50 within 20 work weeks out of the previous 12 months, you may be required to comply. However, if we still, after we run those calculations, don't hit the 50 threshold in 20 or more calendar work weeks, you don't have to comply with FMLA, but the PWFA applies to 15 or more. So you may not be covered under one, but you're certainly, if you have 15 or more, you're going to be covered underneath the PWFA.
Thank you.
Thanks. Okay, let's talk about wage and hour exemptions. So at SESCO, we do a lot of wage and hour compliance. We've done a couple of webinars on it as well for bankers clients in the past few years. So wage and hour is actually going to be your #1 financial liability as an employer. A lot of organizations think it's OSHA. That's not the case. When we talk about wage and hour, there are so many regulations within the scope of the wage and hour division that can come into play. It's not just as simple as minimum wage, overtime, and salary. And those things are big ones for sure. But when we talk about the wage and hour division, again, from an auditing perspective, you could get audited for any reason. Typically, it can be complaint driven, or quite frankly, I've had investigators drive down the road and randomly select a business and they show up and say, hey, I'm here to audit you. And typically they will find something in your payroll records. We've either got somebody misclassified, we're not paying overtime correctly, you've got somebody on hourly and overtime, but you're giving them a bonus that's tied to performance metrics, and you didn't pay the overtime on the bonus. So there are so many minute ways that Wage and Hour can find errors. And then they run calculations. Again, it's a 2-year look back period for all of your locations, for all of your staff, whether they're still with you or not. So that's why when we talk about financial liability, it can very, very quickly add up. Plus, they impute liquidated damages, which automatically doubles your back wage liability there. So it is a lot. Remember that Wage and Hour oversees the FLSA. So at least on a federal basis, minimum wage is still $7.25. Now, obviously, based on your state or even down in your city or locality, you may have a much higher minimum wage threshold than the $7.25. You have to comply with a higher amount, obviously. It also establishes overtime premium at 1.5 times the regular rate of pay, and I'll talk more about what that means here in a minute. For any hours over 40 in a work week. Remember, each work week stands alone for purposes of minimum wage and overtime, okay? So a lot of clients pay on a bi-weekly basis. And I promise you I get this question no less than 3 times a week where, hey, Jamie, I pay on a bi-weekly basis and the employee out of the 2 weeks averaged 80 hours. Okay, for the 2-week payroll period, but in the first week they worked 45 hours, and in the second week they only worked 35. Do I owe them overtime? And the answer is yes, because each work week stands alone for purposes of calculation. Okay. The FLSA also provides what we call exemption from overtime for certain white collar workers. These are your full exemptions. Okay. Now, depending on your industry, you may have what we call partial exemptions from overtime. Retail 7I, if you're an automotive dealership, not an automotive service shop, but a dealership, then you've got automotive 13B10. Trucking industry has the motor carrier exemption. There are different partial exemptions from overtime for carnivals and fairs and all of these other things. There's about 33 different partial exemptions from overtime. Okay. So what is going on right now is that the Department of Labor has made proposed changes to the white collar exemptions. Now, the last time that these exemptions were tweaked started in 2016 under the Obama administration, where they said, okay, look, we need to increase the salary threshold associated with these exemptions. Now, that went through a whole lot of litigation. Department of Labor issued regs. Then there were court cases that put a stay on it. They battled it out until they were finalized in 2020. Okay, so it's been about 3 years. And Department of Labor is basically saying, because of inflation, because of other things, we recommend increasing the salary amount again. There was a lot of speculation this time last year because the Department of Labor was supposed to have issued the notice around fall of last year, and that kept getting delayed. We thought it was going to be in May. Obviously, it got delayed again. So they finally have released those proposed increases to these exemptions. Okay, remember that the white collar employees are possibly classified as exempt under executive, administrative, professional, highly skilled computer, outside sales, and highly compensated. Now, let's talk about exemptions. Just because we pay somebody on a salary does not mean that they are exempt from overtime, okay? Each one of these exemptions has both a salary test as well as duties tests that must be met, okay? It is an all or nothing approach. If they meet the duties but not the salary, it's a no-go. If they meet the salary but not all of the duties, it's absolutely a no-go, okay? So having somebody misclassified as salaried, and if they're working over 40, we've got liability as the employer, and we need to modify their compensation structure, Okay. So again, white collar exemptions, you've got your salary basis. This is a set fixed amount per week. It's guaranteed whether I work 1 hour or 80 hours, no matter what, I'm getting this salary. Now, how we get to that is up for a lot of scenarios. You can't just dock people's salary if they don't show up. You may apply paid leave to make them whole for the week. There are a few scenarios where you can dock from a guaranteed salaried exempt individual, but they basically have to use all of their paid leave available to them first, and then you can only dock in full day increments. Okay. And so there are pieces there on the salary basis. Obviously, then we have to look at the minimum salary amount and then the duties test as well. Okay, so here's where we're at. Currently, to qualify for an exemption, I have to be paid on a salary basis of no less than a guarantee $684 per week. Okay, that's on an annual basis, $35,000 and some change. Okay, not really a super high threshold to meet. Now, what DOL has said is basically that $684 or $35 a year from 2020 now really based on inflation should be around 42, 43,000. And DOL says that's really not enough in our minds. And if we go back to the 2016 argument, really they wanted to make the guaranteed amount $913 per week. And then through litigation, through revision, through the open employer comments, per the Code of Federal Regulations, that's how they came back down to the 684. Okay. So what DOL has proposed is the new salary threshold will be a minimum of $1,059 per week. Okay, which is roughly about $55,000 a year. Okay. Again, this is in the 60-day comment period. Any employer, any U.S. citizen, Joe Schmo off the street is allowed to go in and provide comments through the proposed regulation. You can provide your feedback. You can agree, you can argue your point, you can disagree and argue your point. Okay. So again, this is not a done deal per se, but they are proposing $1,059 guaranteed per week. And again, you still are going to have to meet the duties threshold with these to even appropriately classify somebody as exempt. So what do we do now? Even though it's not a done deal, we strongly recommend that you start assessing your liability. You need to look at who's on salary, how many hours do they typically work, what industry are we in, and could we possibly implement an alternative pay plan structure for them? Okay, there's a lot of options there. There's fluctuating work week, there is reduction of hours, there is putting them on a salary plus commission. There's a lot of ways that we can get you back into compliance. So, you really want to assess your liability. If you have not had a full wage and hour audit with your employment attorney, whether that be SESCO or somebody outside, I strongly encourage that because, like I said, there is probably other areas within the wage and hour oversight that we might not be in compliance with on top of the salaried exemptions. So you want to make sure that you do that. That's something SESCO can do for you. You certainly can reach out and we can talk more about that separately on an individual basis, depending on whether you're a retainer client or a association member there. So when we do the assessment of the liability and we, let's just say hypothetically, we find out, oh, we've got a couple of people that probably aren't going to meet the threshold or their duties don't meet the tests. We've got to look at budgetary effects. We've got to look at restructuring that job pay plan. We're going to have to also look at required time cards, whether that be electronic, thumbprint, biometric system, or physical time records. Wage and hour is very specific that anybody who is not considered fully exempt must maintain a true and accurate record of time. that time needs to not be generalized. So what I see often in audits when I'm working with clients or I'm defending a client through a Department of Labor Wage and Hour audit is that time records are showing Monday through Friday, 8 hours, 8 hours, 8 hours. It's not going to work, folks. It's not going to work at all. I want to see when they clock in, when they leave for a break, that is at least 30 minutes or longer. And when they come back, and then when they end for the day. There's a variety of reasons there. Wage and Hour knows employees don't work exactly 8 hours every single day. Okay. They don't start at 8 o'clock on the dot every day and leave at 5 or 5:30 every day. There's variation there. So having true and accurate time records is really, really important. Okay. Then what we also would look at is analysis of overtime hours. What is our risk? Are we paying bonuses, spiffs, or commissions to hourly non-exempt people? Is the overtime there? I'm looking for travel time, on call, meal periods, all of the things, okay? So what we want to make note of is there a risk when we turn a current exempt employee into, overtime hours worked? That can also be a red flag to wage and hour of, they may not have necessarily always been exempt from overtime. So it's a balance game there, but you absolutely should have your liability assessed. Okay. Again, I think doing a professional audit is a smart idea. If you haven't had one in a while, or you've never had one at all, please get that scheduled, because there are ways that we can reclassify, we can implement things. And this is our golden opportunity to analyze and correct any misclassification. And our excuse says, look, the law is changing, so we had to make the change, right? We kind of just downplay it a little bit. Now, we also get this question. If we have employees that may be affected by this change, can I continue to pay them on a salary? Yes. But remember, they're going to be required to keep a time record. So it's not uncommon to see a salaried non-exempt employee. I run across that all the time, but you have to have a time record. And then we also have to pay overtime correctly. You can't back yourself in per se and say, oh, well, this $1,500 a week covers your regular hours plus your overtime hours. That's not going to work. Department of Labor isn't going to accept that. So yes, we can kind of back ourselves into certain things, but not trying to justify that the salary each week covers regular hours plus overtime hours. Okay. You can do a straight time calculation where you basically take that $1,500 divided by the total number of hours worked that week, which gives you your regular rate of pay for that week. And then you can take the half time, because you've already paid the one of the 1.5 times of overtime. So you would only owe the 0.5 or the half for the hours that exceeded 40. Again, if we have those situations, that's where you can really work with your consultant to rework the calculation so it's compliant and we're not opening ourselves up to liability. Okay. A few other things to remember: no employer is required to guarantee overtime work. It should be approved by the supervisor. Also, you are not required to pay an employee more compensation as non-exempt than you would as an exempt employee. But you also don't want to try to back yourself into that hourly rate. Okay, that's what we try to call hidden overtime, and we want to avoid that there. So with this proposed change in regulation, be prepared that when we do analyses and we make changes to pay plans, there will always be potential issues with morale and perception. Some employees view it as a demotion where they go from salary to hourly. Some people don't like keeping time records. So, this is where your consultant can really help you prep and plan communication strategies around how to present these changes without, completely disrupting the morale and culture. Okay. The other piece is when we do make adjustments, we're obviously going to have to do some training with the employee themselves on what their requirements are with meal and break periods, what their restrictions are on working outside of normal business hours, whether they're taking calls after hours or doing emails. All of those things are compensable, and I'll talk more about that here in just a minute. And we may need to tweak or rewrite our current internal policies and procedures there. So let's plan, let's be proactive about it. Again, do your internal analysis, schedule your audit, look at where we're at with budget compared to payroll and benefits. There are a variety of ways that we can kind of defer increases, and I'm not suggesting that you have to or that you should, but each approach will be customized to your organization that makes sense. And we'll tweak those pay plans there with you. Okay. Quickly, just a few things that I see in my dealings with the wage and hour. Again, I've been with SESCO for over 16 years, and I do a lot of wage and hour audits, both on the client level as well as defending the client in wage and hour investigations. And the first thing that they look for, obviously, is those misclassifications of exempt, non-exempt. Typically, I see a misclassification of the administrative exemption in particular, where we have office individuals, payroll people, HR specialists, accounting staff that are paid on a salary that really should not be paid on a salary without being paid overtime appropriate. Computer individuals as well. In order to classify under the computer exemption, you've got to be basically writing programs, developing programs. The computer exemption is not for your general IT person, your help desk person, the person that's setting up laptops and issuing out passwords and those sorts of things. It's not going to work. Okay. So misclassification is always trap number one. Trap number two will also be not understanding what is considered compensable time. Okay. Many of us have certain procedures in place where if an employee clocks in within a certain time, it's either rounded back to the hour or it's rounded forward to the quarter hour. So you may have individuals that are clocking in and riding the time clock, which is pushing them into overtime, or they're late clocking out. So we've got to manage the time. Remember that payroll is our number one controllable cost, okay? You may have people that are working off the clock, whether it, again, taking emails or calls at night. If it's for the benefit of the employer, it's compensable time, okay? If you have somebody that is eating their lunch at their desk and picking up the phone or answering emails, it's compensable time. They're not free and removed from work. There are very specific rules surrounding travel time, whether that travel time is within the same day, overnight, away, travel time in between locations. Some industries have asked me, look, Jamie, I pay them for mileage instead of travel time. Is that okay? No, it is not. Mileage is not required to be reimbursed or compensated, but travel time is. Okay, so it depends on where they're starting, where they're going. Is it overnight? Is it in between locations? There's a lot of nuances there with that travel time. Okay, same concept with on-call time. If I am free to go and do whatever I want to do while I'm on call this weekend, then I'm called, waiting or I'm called waiting to be engaged, meaning I'm free and able to do what I want. So when I'm waiting to be engaged, you only pay me for the time once I pick up the phone and take that on-call call, right? But if I'm engaged to be waiting, meaning I can't go outside of a certain mile scope, I have to respond within, 10 or 15 minutes or be on site within 30 minutes. You've limited my ability to go and do, which means from the time I start on call to the time I end on call that weekend, you owe me the entire time. Okay. So on call can get a little tricky too, depending on your industry and what the parameters are surrounding that on-call time. Okay. Again, trap number 3 is not paying for off-the-clock working hours. If an employee works overtime, even if it was not authorized by the supervisor, you are legally bound to pay it. It becomes a disciplinary situation. If we have employees that are working unauthorized overtime, you need to follow your performance management processes there. And again, short clocks on meal periods, anything under 30 minutes is considered compensable per the wage and hour division. Now, I mentioned regular rates earlier, right? So overtime is based on regular rate of pay. So regular rate is defined as total monies earned divided by total hours worked. Okay. So if I am a $15 an hour employee, right? And let's just say I get a $100 bonus this pay period because I met my performance goals. Or let's just say you have an attendance bonus. Jamie, I'm going to give you $100 with, this pay period because you haven't missed a single day out of the last 30 days. That's what we call non-discretionary bonuses. It's tied to a metric, meaning if I hit this metric, I'm going to get this money. I know that, right? So when we have non-discretionary bonuses, you have to pay the overtime on the bonus because in essence, that $100 has to be added into the total monies that I earned that week, divided by the total hours that I worked, which is going to increase my regular rate of pay. I'm no longer a $15 an hour employee. I'm more of a $15.75 an hour employee. So your overtime has to be calculated on that $15.75, not the $15. Okay. Now, if you're using a fluctuating work week method, you can't pay bonuses or incentives along with that. Again, with fluctuating work week, please do not implement that program without review and consult from your employment attorneys at SESCO or your consultants at SESCO. Okay. Trap number 5 is making improper pay deductions. Remember, we can't deduct anything from an employee's wages without signed written consent. Outside of your normal taxes, everything has to be authorized. Benefits, 401k, uniforms, damages, so on and so forth. And state law is going to dictate what you can and cannot deduct as well. So you don't want to deduct without having a specific signed deduction authorization agreement. I want to see the amount, what it's for, how long the deduction is in effect. Is it a one-time or is it, for the next 20 work weeks? Those things can get you into some major trouble as well. Trap number 6 is going to be your incomplete record keeping. Again, time records, payroll records. In your payroll journal, I want to see regular hours, overtime hours, bonuses, on call. Everything should be a separate line item so that if we are ever audited, it is a beautiful little package where the investigators themselves can see exactly how the hours associated with the monies worked. Okay. Any questions about wage and hour before we move on to the I-9s?
Yes, we have
a little tricky. So, and I know it typically yields a lot of questions, but Lauren, what you got for me?
Yes, we have about 6 questions. So the first one is, how does the PWFA work for companies with less than 15 employees?
Yes, as I mentioned, and depending on what state you are operating on, the PWFA only applies to employers with 15 or more. If you have under 15, you are likely covered by a different state compliance provision. So here in Virginia, for example, we have the Virginia Pregnancy Act. All employers, even those under 15, are required to comply with the Virginia Pregnancy Act, which basically has similar provisions of the reasonable accommodation requirements. So that's a good question there.
Thank you. The next question is, are there forms for both the PWFA and the PUMP Act?
That's a great question. Not at this time, but remember with the PWFA, we're treating it similarly as we would with the Americans with Disabilities Act. So there are reasonable accommodation forms for the interactive process, for the medical certification. If you're a retainer client of SESCO, then that's part of your retainer agreement where you can get those forms. If you do not have those forms, you can purchase those through the SESCO website or reach out to me individually and we can work that out.
Thank you. The next question is, are we required to pay overtime for workers that their primary role is commission-based in construction? There are times when they work a combination of commission and hourly.
That's a great question. So construction, it depends. If we're talking about just a non-federal contractor, if they're paid hourly plus a commission, yes. If we're talking about a federal contractor construction, then we're getting into the Davis-Bacon Act with the prevailing wage rates and that sort of thing. So without knowing the specifics of this employer and the specific position and the pay structure, besides the hourly and the commission, because you can't, just because we pay somebody a commission doesn't necessarily partially exempt them under Retail 7I. I've got to look at more specifically at how the commission is structured and how that plays into their duties. So what I would suggest there is we may have some liability, and I would strongly encourage you to reach out to us individually so that we can talk offline about your particular circumstances.
Thank you. The next question was, I was told if an employee clocks in early or clocks out even 2 minutes late, even if they are not working during that time, we have to pay them overtime.
Well, so overtime is calculated on 40 hours each work week. So if those early and late clockouts are pushing them into overtime, then hypothetically, yes, you would owe them that overtime. More specifically, again, this is an area of opportunity to reach out to SESCO and talk more offline, but without knowing what their current pay practices are, I don't know whether they're using the 7/8 method of rounding, whether they're using 100ths down to the minute for their timekeeping systems. That 2-minute clock out, if they're rounding, should round back, so it should be a moot point. Depending on how early they're clocking in, again, if we're rounding, that may also be a moot point. So again, overtime is only paid when we exceed 40 hours per week. We're not in California where there's an 8-hour per day rule. So although we may, if we have anybody from California on the line, but typically Virginia, Maryland, North Carolina, it's all following the 40-hour a week rule.
Thank you. The next question is, we are a brokerage company that pays all of our employees' salary. Our payroll is calculated at 86.67 hours per pay period. Should we be using time cards to track time?
It depends. You know, there may be some of those employees that are exempt. When we're talking about brokerage firms and looking at different exemptions, you know, certain sales agents may or may not be classified as exempt. Again, looking at the structure of the pay plans, it's never going to hurt you to keep time records. Obviously, those can be helpful in audits to defend us if the employee is saying, look, I work 95 hours a week. And we say, no, actually you work, you know, 80 or whatever it may be. So certainly, even if you do have exempt employees, you can still require them to maintain time records. That's not going to hurt you. But I think what we may want to do is, again, look at each position that you have on salary and make a determination whether they are correctly classified before we get into who needs to keep a time card and who doesn't.
Thank you. Our last two questions are, when does the 1059 take effect?
Yeah, great question. They haven't said. Again, typically when they issue the proposed regulations, it has to go through that 60-day comment period. And then they close that 60-day comment period, determine whether or not they are going to make any revisions to the proposal. And then they announce the final regulations and when those regulations will take effect. I mean, we're in September now, which will put us into November for the comment period, which likely they would issue final regs before the end of the year. Typically, I would say anywhere from January till July would be typically your sweet spot for changes or implementation of the new regulation. Certainly, we're monitoring this and we'll notify our clients and the clients that are enrolled through the Bankers program via our client alerts when we have a more definitive date for enactment.
Okay. And then, can an employer make you leave early to remove overtime on the last day of the work week?
That's a great question. If the loaded question too, Lauren, if there is legitimately no work available, the employer does reserve the right to send individuals home. Now, that also kind of leads me into a conversation on what we call comp time. Okay. Comp time is saying, hey, Lauren, you worked, over 40 hours this week, but instead of paying you your overtime, I'm going to let you take time off next week. Or I'm going to give you that value in PTO to use for the future and not pay you for the overtime this week. Comp time is illegal for private sector employees. Okay. So don't do comp time. Comp time is not necessarily PTO and vacation and sick leave. Comp time is basically saying, look, I'm not going to pay you overtime, but I'm going to give you time off later to kind of level you out. That's not going to work. In terms of sending them home, possibly. It depends on the circumstances. If it is very blatant that I'm sending you home, there's work that I need you to do, but I just don't want to pay you overtime, you're teeter-tottering on that line. Is it illegal? Not necessarily. It's just not a good practice.
Okay, thank you. And then the last question was, if a business is registered in one state but performs work in two states, do we need to comply with, how do we comply with the employment laws?
Yeah, that's a great question. So remember that if we're doing business in another state, that's going to require us to have state filings with the other state. So you're still responsible for state taxes, worker comp regs in that state. If that state has paid leave laws and you have employees working in that state, you're likely going to have to comply with the paid leave laws. So this is a nice reminder that if you have not had your employee handbook reviewed and updated based on your locations and where you are performing work, you probably want to have that reviewed by a solid employment attorney or SESCO. Our attorneys are our consultants as well. As a banker's client, you can have it reviewed for a flat fee of $350. That gives you a review report. It does not give you the revisions, but it will tell you what the handbook needs and what the discounted fee to do those revisions would be. So if you have specific state questions, what I would suggest is if you're enrolled in the Bankers and SESCO program, feel free to reach out and we can walk you through those particular state requirements.
Okay, thank you.
Any other questions, Lauren?
That's it.
Okay, perfect. Let's roll into I-9 and then we'll wrap because I know we're coming up short on time. It's been a little bit of time since the I-9 form was updated. As you are aware, at the top right corner of every form is what we call a date of employment where the form expires. So the current form in place expires at the end of October. You can continue to use that. now through the end of October. However, effective November 1, the USCIS has issued a changed form. I'll cover what those changes are here in just a minute. If you are an employer who is enrolled in E-Verify, you have the ability to also remotely examine employee documents through that, okay? But remember, not all employers are required to comply with E-Verify. For most, it is optional, okay? If you are a federal contractor or a federal subcontractor, you are mandated by law to comply with E-Verify. So if you are using E-Verify, the revised I-9 form has a checkbox designated when you have remotely examined the employee's documents. That flexibility goes into effect August 1, okay? Now, when we were in COVID, there was some flexibility there from the USCIS and Department of Homeland Security that allowed employers to remotely verify, okay? But now what they're saying is that's only going to apply to E-Verified employees, okay? So in order to take advantage of the remote option of verification, you have to be enrolled in E-Verify. Again, for most employers, that is optional. You have to examine and retain the copies of all documents. That's no different. We have to do that anyways. You must conduct a live video interaction with the employee and create an E-Verify case if the employee is a new hire, okay? Now, here are the changes on the I-9 form. Remember that the I-9 form in its current format is 3 pages. You've got page 1, which has the employee information, the preparer section. Then page 2 is, list A, B, and C, and the certification section. And then page 3, which also stays with the form, is the list of acceptable documents. That's how it's currently structured now. With the new form effective November 1st, sections 1 and 2 are in one single page. So that means your employee section, the verification of either list A document or list B and C is all on the first page, okay? They've also modified it to be fillable forms on tablets or mobile devices, okay? Now with the translator or preparer certification, most people are not using this section. The only time you're really going to use that is if somebody physically or mentally cannot fill out the form, okay? That is now a standalone supplement of the form where you can give the employee a single copy page if needed. Again, most employers are not using the preparer or translator certification. Section 3, which is for re-verifications, is also now a standalone form, okay? So remember, the only time that you re-verify documents is when my list A document expires. That's your passport, your visas, okay? Or my name changes on a list C document. Typically, it's going to be a social security card. So for example, I finally got around to changing my name post-marriage. So because my name legally changed, my employer, SESCO, had to re-verify my social security card, even though it doesn't expire, because my name had changed. So they had to fill out section 3, the re-verification, okay? Also, you use section 3 if you rehire an individual. Say they've been gone for 6 months, a year, and they come back, then you just re-verify those documents, okay? So section 3 is no longer on page 1 or 2, it's a standalone form, okay? Acceptable documents, the list of acceptable documents, remember that has to stay with the I-9 form. That is revised to include receipt notices for certain filings that would automatically extend employment authorization, okay? So there will be some information there with acceptable documents. The form instructions have been reduced from 15 pages to 8 pages. And then that checkbox for the E-Verify employers has already been included, as we previously noted that above. So not a whole lot of life-changing changes there, but just some updates with the Form I-9. So I know I threw a lot of information at you in a very short amount of time. So if there are any additional questions, Lauren, I would love to hear those. I'd be happy to answer those. But in the meantime, remember, please feel free to give SESCO a contact or reach out and contact us today, and we can walk through some specific scenarios that may be of concern for your organization.
Thank you so much. We have 2 questions about E-Verify.
Okay.
The first one is, if already enrolled in E-Verify, will the employer need to do a re-enrollment to continue to use before November 1st?
No. If you're already enrolled in using it, you wouldn't have to re-enroll.
Okay. And then the next question is, do we need to E-Verify for CPT employees?
I'm not sure I understand the question.
I think they mean contract employees who work for only a few months.
Oh, well, that gets me into it. Well, again, it's going to go back to whether you're a federal contractor or a subcontractor. Because when we say a contract employee, I don't know whether they're talking about a 1099, which is a whole nother discussion for another day, because it's very difficult to truly 1099 somebody, or whether they're talking about a federal or a subcontract requirement. So if they want to reach out to me separately, I'd be more than happy to kind of flesh out that question a little bit more with them.
Okay, they clarified it's about college graduates who want to do a summer internship.
Well, no, because you're not, certainly you can enroll in E-Verify, but if they are being hired as an employee and you are enrolled in E-Verify and that's what you're using, then certainly you would submit them too. If you're not enrolled with E-Verify, even if they're doing a summer internship and you're hiring them as an employee, they would still need to complete a Form I-9.
Okay, thank you. The next question is, when you say the acceptable documents must stay with the documents for I-9, do you mean the employee's documents themselves or the acceptable documents explanation page?
Oh, that's a great question. Actually, both. So definitely the list, the page that is part of the form, because it's part of the form. And then if you are making copies of those documents, a lot of employers will photocopy birth certificate or visa or driver's license, whatever they're presenting to you, and keeping photocopies of that. Those copies must also remain attached to the form. They can't be floating around in the personnel file.
Okay, and then this kind of adds on to that same question.
Okay.
Is the list of acceptable documents to be maintained in the ER file as part of the document or just provided initially to the EE?
It has to be provided to the employee so that they know what documents they can produce. Remember, as an employer, I can't tell you to bring a driver's license and a social. I can only simply hand you the list and say, hey, you either need one from A or one from B and C. So when they bring in those documents, the form itself is pages in its current format 1, 2, and 3. So that is the form. And that is what the USCIS would look for and audit you for as to whether that list is with the document. Now, part of that question talked about the form being in the employee file. We do not recommend that the I-9 form be stored in the actual employee file. You should have all of your I-9 stored separately from the main personnel file. You need to have a separate file for your I-9 sorted by active employees and terminated employees.
Okay, thank you. I believe that's all the questions.
All right. Well, thank you all very much. Again, if you have follow-up questions, I would be more than happy to assist. Our telephone number is obviously here. My email address is Jamie, JAMIE at SESCO, SESCOMGT.com. Feel free to shoot me a message, but otherwise, Lauren, I'm going to turn it back to you.
Thank you everyone for your participation today. We appreciate it.